Good evening, everyone present here. Today we have Dr. Divya ma'am with us, who is been working currently as an associate professor in Department of Agada Tantra in SDM Bangalore. First, I'll be giving introduction about the Panchajanya organization. Panchajanya, the divine conch of Bhagwan Sri Krishna, which was blown during Kurukshetra, indicating the start of Dharma Yuddha that followed. There, all the efforts were done for the establishment of Dharma. Dharma was kept over personal relations and motives. Keeping the same motto in mind, our organization will work towards establishing the importance and necessity of following and imbibing Bharatiya culture, accepting our roots, and making people realize the true essence of Ayurveda, not only as a treatment modality but also as a way of life. All this while working in a path of Dharma. Hence the motto Shreyam Bharatiyam, Arogyam Ayurvediyam. The founders of this organization started this because we felt the need to spread the knowledge of Bharatiya culture, Ayurveda, the true history of Bharata Shastra, and values to all the states of people in every corner of the world. Also, the founders being Ayurvedic aspirants, known the inside out of today's medical field, hence they aim to make people aware of this and also try their best to solve this on the go. This is an organization that is created by 28 young, energetic individuals of 21st century, where all have left behind their differences, insecurities, and have come together, united for the betterment of this great nation and its heritage as a whole. We at Panchajanya recognize each and every individual's true potential and make sure they reach their maximum. Everyone who is part of this family performs on their own will but within the limits of services and contribution. In order for in order for all this to be achieved, we have set up various wings with working principles and objectives that help achieve the goal faster and easier in the coming years. They are Ahilyabai Wing, Swami Vivekananda Wing, Karnataka Wing, Govardhana Wing, Ashwini Wing, Narada Wing, Kautilya Wing, Vedavyasa Wing, Nalanda Wing, Sanjaya Wing. Coming back to the members involved in our organization, we have doctors, healthcare workers, teachers, students, and people from almost every single occupation available aiming at working together and bringing forward the true essence of Bharata and her traditions. So, all those who fit under these categories are welcomed with honor and privilege. Today, Dr. Divya ma'am will be taking the topic negligence and act related to medical field. Ma'am has completed UG in Government Ayurveda Medical College, Bangalore. Ma'am has pursuing PhD in Rashastra under guidance of Dr. Sureka Madikeri, Principal of Government Ayurvedic Medical College, Bengaluru. Ma'am has published articles of around 8. Ma'am, we are very happy and honored to be hosting this session, ma'am. You can continue over the session.
So, good evening, one and all. So, in today's class, the point number 15 in the syllabus will be dealt. So, the first topic in that is physician's responsibility in criminal matters. So, firstly, medico legal cases. So, what are the responsibilities of a physician in medico legal cases? So, before going into detail, firstly, there are a category of cases which need to be labeled as MLCs or medico legal, which include accidents, it can be traffic, machinery, or animal, assaults, all sorts of assault, poisoning cases, cases brought death, sudden unexpected death, suicide, homicide, poisoning, and so on. So, the first priority in any case should be given for treatment of the patient, and then comes operate the procedural criminal law. So, the examination of an MLC will include few points. First thing, the examination will include to obtain a consent from the patient. Then comes at least two identification marks of the patient should be noted, which will be individualistic. Then, in all medical legal cases, details of examination of injured person, whether he is being admitted to the hospital or whether he is treated as an OP, it needs to be entered in the register, which is the accident register. The next duty is to inform the police or the investigation officer if the case is known. Next point is to obtain the general history and specific history regarding the particular incident from the victim. In case of if it is a criminally accused person, attempt should not be made to obtain any history of specific incident, and the question should be limited only to cause of injuries alone. If death is imminent in spite of due care and treatment, then the physician should immediately arrange for dying declaration. Immunization, wherever it is required, must be given, and necessary investigation must be carried out. All the collected evidences should be properly preserved, packed, and sealed, and produced as evidence in the court of law. In all the criminal cases, it is always better that a physician obtains a second opinion from an expert wherever it is required. All the forms, whichever have been filled, including x rays, other investigations, they should be labeled as MLC. If there is death, then he is responsible to inform the police and death certificate should not be issued. The autopsy to be conducted, it is discretionary power of the police and not the doctor. And postmortem report is a confidential report and it should be given only to the investigating officer. It is not a public document. So these are certain basic things a physician is responsible to do in criminal cases. So first thing, the importance is to be given to treatment of the cases. Then operation of criminal law, which will include examination of the MLC cases, obtaining information, consent, collection of evidences, information to the police. If the patient is serious and death is imminent, arrange for dying declaration. If death occurs, do not issue death certificate. On request of investigation, autopsy should be posted. All the required evidences must be carefully preserved and produced in the court of law. These are in general. Then the legal issues include, according to section 39 CRPC and section 176 IPC, a doctor who is aware of commission of crime such as murder, dacoity, or waging a war against lawful government or helping the escape of prisoners, etc. Once he is aware of such criminal matters, he is bound by the law to report such things to the nearest magistrate or police officer. If he fails to do so, he will be charged for the offense. Then, as per section 202 IPC, the doctor, knowing or having reason to believe an offense has been committed by a patient whom he is treating intentionally, omits to inform police, shall be punished with imprisonment up to 6 months. That means a patient who is being treated by the doctor, and if the doctor comes to know that he has committed some sort of crime, then he is responsible to inform the police, failing to which he can be imprisoned up to 6 months. But it is not, there is an exclusion that if the physician is treating a case of suicide, then he is not legally bound to report. But if death occurs in such cases, then he has to report. Then the practitioner's responsibility in case of criminal abortion and poisoning, that also can be written under physician's responsibility in criminal matters. For example, in case of suspected poisoning, first thing is treat the patient, shift the patient to a safe area. All the suspected material, poison or any evidence available should be collected and preserved, sent for investigations, and such other points which are dealt in the cases of poisoning can be written here also. So this is regarding the first topic, that is physician's responsibility in case of criminal matters. So first thing is it will include the medico legal cases. So if in the exam if it is asked physician's responsibility for criminal matters, First thing is they are medico-legal cases. Definition of medico-legal cases, what are they? Then what are the basic duties of a doctor to do in such cases, medico-legal cases? Which are the cases you can term as MLCs, and how to carry about in a case of such MLCs, what are the duties to be performed? Then the legal points include Section 39 of CRPC, Section 176 IPC, and Section 202 IPC, which are depicted in the slide. Other than that, the points which could be included here are responsibility in case of criminal abortion, responsibility of physician in suspected cases of poisoning. Those are dealt in those specific topics. That responsibilities and duties can very well be written under this. So, with this, we conclude the first point. Now, coming to the second topic, professional negligence or malpractice. So, negligence in general means doing something that one is not supposed to do, or not doing something which a person is supposed to do. That is in general definition or meaning of negligence. Now, coming to what is medical negligence, professional negligence, the definition goes: absence of reasonable care and skill or willful negligence of medical practitioner in treatment of patient which causes bodily injury or death of the patient. So there are 3 4 points in this. First is absence of reasonable care and skill. What is this reasonable care and skill? The proper attention which a patient deserves, if that is not given. Willful negligence of a medical practitioner, the practitioner being knowingly negligent about the case, and then he treats the patient with negligence, not giving him care, that will result in either an injury to him, a permanent disability, or a damage or any sort of harm, or sometimes leading to death of the patient. This is called as professional negligence. So, professional negligence occurs usually in two situations. One, deviation from the accepted practices, a treatment protocol when they are deviated, or employing the accepted practices unskillfully, not skillfully presenting the medical care and attention. So, these are the two things or situations where a doctor puts himself in case of professional negligence. So, in medical negligence or professional negligence, examples include failure to obtain consent from the patient while doing any procedure, refuse to see an emergency case, not carrying out necessary investigations or carrying out unnecessary investigations, mistake of labeling, wrong diagnosis due to absence of skill or care. All these are examples for medical negligence. So, in negligence, we have four different types: civil, criminal, corporate, and contributory negligence. Civil negligence. The question of civil negligence arises in two situations. One, patient or his relative bringing a suit in the civil court, filing a case in the civil court against a doctor, alleging negligence and asking for compensation. The other situation is the reverse, wherein doctor brings the civil suit against the patient, alleging negligence to get his fees from the patient who have refused to pay him the fee, alleging that he is negligent. Okay. So civil negligence arises in two things. One, patient filing a case against the doctor for negligence, or doctor filing a case against the patient for receiving his fees. Here, the plaintiff or the patient will have to prove four things, that is, duty, dereliction, direct causation, and damage. So, the first one is duty. The patient is supposed to prove that there existed a patient and doctor relationship. Means the doctor has seen the patient or consulted the case. There exists a relation between doctor and the patient, wherein doctor holds a responsibility to take care of the patient. Second one is dereliction. Dereliction is breach or failure on the part of physician to exercise his duty, means not taking due care and skill towards the patient. He is failing in his part in doing the duty. This could be because of act of omission or act of commission. Act of omission is not doing things which needs to be done. Example, in all cases of injury, a physician is supposed to provide a anti-tetanus prophylaxis. So suppose he fails to do that, then it accounts for act of omission. Next is act of commission, doing something which he is not supposed to do. For example, doing a surgery under the influence of alcohol. So that is dereliction. Dereliction is breach or failure on the part of physician in performing his duty. It can be not doing a thing which to be done or doing a thing which need not be done. Next is direct causation. Direct causation means because of the second point, breach or failure of the doctor, patient has some sort of injury or harm. That comes under direct causation. Now coming to damage. Damage is as a result of the breach shown by the physician. Patient suffered some amount of harm or injury, and this harm or injury caused him a certain damage. It could be a permanent disability, or for example, it could lead to him not going for his occupation. Okay. So this damage was very well foreseeable by the physician. He could have avoided it. Such things comes under the damage. So it is the liability and responsibility of the patient to prove these points under civil negligence. First thing is to prove that there existed a physician patient relationship where the doctor has seen the case. Second one, dereliction. There was failure on part of the doctor to do his responsibility. Third one, because of his irresponsibility, patient had some sort of harm or injury. Fourth one, damage. The injury or harm resulted in certain amount of damage to the patient. So these 4 points should be proven by the patient in order to apply for civil negligence. Now the second one is criminal negligence. Criminal negligence is a gross negligent act. The civil negligence is a smaller version, while criminal negligence is a gross negligent act because of which there is a serious injury or death has occurred. Means the doctor has shown gross negligence, carelessness in taking care of the patient. So this goes for a criminal offense, and it is not going to settle in mere terms of compensation. So it involves extreme departure from the standard of care. That is criminal negligence. So section 304A, section 337 and section 338 deals with the criminal negligence. As per section 304A IPC, if death occurs, then the doctor has to be prosecuted or can be prosecuted. As per section 337, 338, if the doctor acts rashly or negligently, either endangering life or causing hurt or causing grievous hurt, either of this condition, whether it is satisfied, he is causing hurt, endangering life, or a grievous injury, then he can be prosecuted. Examples for criminal negligence include amputation of a wrong finger or wrong limb or sometimes wrong person itself. So it is a gross deviation from his skills. Then leaving instruments or tubes inside the abdomen after performing the surgeries. Performing criminal abortion. administering wrong substance into the eye, which may lead to permanent loss of vision of the patient. So these are examples for criminal negligence or gross negligence that can result in serious injury to the patient or even death of the patient. So you have to know the definition of criminal negligence, what are the sections dealing with it, and what is the example. Now coming to the third one, that is contributory negligence. So contributory negligence, here both patient and the physician both are responsible for the harm or injury that is being caused. The definition: any unreasonable conduct or absence of ordinary care in part of patient or his personal attendant combined with doctor's negligence contributed to the injury as of direct proximate cause and without which injury would not have occurred. So, adding to the failure on the physician's part to carry out his responsibility, here the patient is also, or his personal attendant is also responsible for the damage that has occurred to the patient. For example, failure on the part of patient for not giving a proper medical history or refusal to take whatever the physician has suggested treatment, patient refusing to take the treatment, or leaving a hospital against the doctor's advice. If symptoms persist, he is not coming it for further medical assistance. So these all contributes from his point along with the negligence of the doctor. Then it comes under the contributory negligence. Here, the doctor's negligence is not the direct or the actual cause of injury which is being suffered from the patient. Okay. But still, the injury or harm has caused because of negligence on both the parts, then it comes under the contributory negligence. Last one is corporate negligence. So, corporate negligence, this is based on the principle that hospitals are in a far better position when compared to patient to supervise a doctor's performance and provide good quality control. So when the breach occurs in the physician's responsibility or in the hospital as such, then it comes under the corporate negligence. Here there are more than one people involved in rendering service to the patient, as a result of which there is damage caused to the patient. For example, use of defective equipments in the hospital, failure to provide proper accommodation, facilities, or whatever treatment is prescribed, failure of not exercising them properly. So the contribution is from a hospital or a source as such, then it becomes a contributory negligence. So in negligence, firstly, absence of care or willful negligence of practitioner in treating, causing him injury. So all 4 points must be there in the definition: absence of care, willful negligence in treating patient, causing injury or death. In that we have four types: civil, criminal, corporate, contributory. Civil, it is smaller negligence caused by the physician. So here it can be two: patient charging complaint or physician charging the complaint, either ways. And he is supposed to prove duty, dereliction, direct causage, and damage. Criminal negligence is gross negligence which has resulted in a serious injury or death of the patient. So, related sections and examples. Then coming to contributory negligence, here the failure is on part of physician as well as the patient also has contributed for contributory negligence, not giving history, etc. Corporate negligence is when more than one person, mean at a certain level, more than him, many are involved in not giving proper service to the patient, resulting in the damage to patient. Then comes under corporate negligence. Next is how to prevent this negligence. First point, rapport. The physician is supposed to maintain a good rapport with the patient and patient families, not only to the patient but also to the fellow physicians, paramedical personnel, etc., whose negligence may involve and cause damage to the patient. So, he should maintain a good communication and rapport with the patient, his relatives, the fellow doctors, as well as the paramedical staff. Next is the rationale. The doctor should use reliable information, relevant information, whatever is required to diagnose a case and provide proper treatment. He should be rational in using the diagnostic methods as well as in adopting proper treatment. Next becomes the records. Maintenance of good records, carefully noting down all the points. The records must be complete, relevant, timely, and informative. Next point is remarks. Not to criticize or pass derogatory remarks on the patient or the paramedical staff or x-ray personnel, particularly when the patient is in the premise and hearing it. Okay, if it is very much required, the paramedical or the technicians involved should be taken aside and told what mistakes are being done rather than passing derogatory remarks towards them. Next one is receipt. Receipt means only prescribing medicines which are required, not to prescribe any medicines which are not useful, or unless there is a therapeutic indication for it, only then prescribe medicines. And a physician should be aware of the side effects of the prescribed drug, and he should caution his patient that it can be possible that he could have certain side effects and be prepared for it. Next comes the respect. Respect is to maintain thorough professionalism and humanity approach towards the patient and the fellow workers. Then coming to results. Results here refers to firstly obtain an informed consent from the patient. If any bad result occurs, then immediate attention should be given as long as possible to correct it. Then coming to the risk. To avoid negligence, it is always better to inform the patient and his family as well about all the risks involved. Certain risks which can be anticipated very well. It could be diagnostic or therapeutic. So, in such cases, it is always requirement that the physician informs the patient and his relatives about all the risks involved in the diagnosis and treatment. Then last one is review. Routinely review cases involving morbidity and mortality. Review medical malpractitioner cases and testimony by medical experts. Constant review keeps you updated so that you can prevent yourself putting it into the negligence. So these are the R's which can prevent the doctor from getting into a case of medical negligence. So first thing is maintain a good rapport with the patient, his relatives, and your fellow medical practitioners. Second one, use rationality in selection of diagnostic procedures and treatment. Third one, let the records be complete, accurate, legible, and informative. Fourth, remarks. Do not pass derogatory remarks against any medical professional or paramedical staff or patient, particularly on staff when the patient is listening. Then recipe. Only prescribe only medicines which are thoroughly required for the patient. Then comes the respect, attitude of care, concern, professionalism in the approach. Results, any bad results come, pay proper attention to correct them as soon as possible. Obtain an informed consent from the patient whenever it is required. Risk, always inform the patient and relatives about risk involved either in diagnosis or in treatment, and constantly review the cases related to negligence, expert opinions to avoid any negligence. So these are the points to prevent a case of negligence. So There are certain points in this chapter, medical law and ethics, though it is not specifically underlined in the syllabus. These are certain points which could be asked in the exam as well as in the viva. So I will just brief about them in short. So first one is professional secrecy. So, professional secrecy, as the term itself suggests, a confidentiality should be there between the physician and the patient. It is a contract between the doctor and his patient, which is of utmost trust, confidence, and honesty. So, the doctor, it is implied that the doctor has to keep the things or history, whatever is obtained from his patient, confidentially. Example, a doctor will not discuss the illness of patient with others without the consent of the patient. Okay. Particularly if he is a major, if he is minor, then it could be discussed with the parents what the patient illness is about. Then the doctor should not disclose any patient's confidential matters to his relatives, and if it is wife or husband also, then the consent should be taken from the patient, only then the spouse needs to be informed. The medical officers are bound by the code of professional secrecy that even if he is treating the patient for free, he should not reveal any secrets or details regarding the patient. So there are certain examples for professional secrecy. Now, next one is privileged communication. So, privileged communication is an exclusion for professional secrecy. Means these are certain cases where a physician or doctor can disclose the patient's information to a third party or certain authorities. Examples, say for example, infectious diseases. So, you are treating a patient having an infectious disease who is working in a sector where he is in communication with many other people. So there is a chance that there is a, spread of infection to others. So in such cases, you can inform the patient details to the master or the required authorities. Then, in case of certain notifiable diseases like infectious diseases, as I told you, the physician is bound to inform the authorities about that. Then, in certain cases, it is better for the patient himself to tell his complaint. For example, a patient having a mental illness or suicidal tendency, it is always better to inform his relatives that he is suffering from so and so mental illness, so that he can be treated and proper care could be taken on that grounds. Then certain venereal diseases, if patient is suffering from some sort of syphilis or any STDs and he is going to get married, so it is the physician's responsibility to pursue him, to inform the spouse regarding the illness he has, or to postpone or cancel the marriage. So these are exclusions for professional secrecy, certain points where the physician can tell the details of patient to his people or to his relatives. Next comes doctrine of recepsa loquitur. So doctrine of recepsa loquitur, this also comes under the professional negligence itself. Here the thing is, the patient need not prove that the doctor is negligent. The fact itself speaks for itself. Say, for example, doing amputation, as I already told you, amputation of wrong limb or performing a surgery on the wrong side. Here, the patient need not prove an additional evidence that a negligence has occurred. So, the fact itself that he has been operated on the wrong side speaks for itself. There is no requirement for the patient to give an additional evidence. So that comes under doctrine of recepsa loquitur, wherein the patient need not prove the negligence, or the thing itself, fact itself speaks for itself. Next comes the medical malaccurrence. So medical malaccurrence is a case where, in spite of giving good care, attention to the patient, sometimes the individual may not respond properly for the treatment, or sometimes he may suffer from adverse reactions for the drug which is given. So that is medical mal-occurrence. Unintentionally, patient has suffered, though proper care was given to him. So that is medical mal-occurrence. Next is novus actus interveniens. Novus actus interveniens. This means the physician is not only responsible for his action but also for the sequence of things which are happening. The example for this is, suppose after doing a lapro or during a laparoscopic surgery, the surgeon faints or keeps a swab or surgical instrument in the abdomen, leaves it as it is. Then it becomes a case of novus actor intervenience. That is, his negligent act of leaving an swab or an instrument in the abdomen leads to further complications. So the sequencing goes on. That becomes novus actor intervenience, where the physician will be held responsible for it. Next is, is it audible?
Yes, ma'am, it is audible, ma'am.
Okay. So the next one is therapeutic misadventure. Therapeutic misadventure. This is a case wherein there is an unintentional act of the doctor or the agent or the hospital, but the individual has suffered the injury. Say, for example, a poisoned patient has come, they have given an antidote. Suppose the administration of antidote, what is given, has exceeded, or exceeding amount of antidote has given. So that antidote has caused patient's death. Then it becomes a case of therapeutic misadventure. For example, certain use of medicines, for example, prolonged use of stilbestrol can cause breast cancer. So the doctor is not willingly giving it or intentionally giving it, but unintentionally act also of the doctor or the agent or the drug might cause injury or harm to the patient. Then it becomes therapeutic misadventure. Next one is vicarious liability. Vicarious liability means an hospital or an employer, he is not responsible for his negligence, but also for people under him if they are negligent. Suppose a paramedical staff, the nurse, not taking proper hygiene or certain measures, the damage occurs. Then the doctor also is responsible and he is also being charged. That becomes vicarious liability. Next one is consent. So consent could be asked for a 5 marks. As you all know, consent basically means it is an agreement or permission which is to be given. So why, what are the reasons to obtain the consent? The reasons include, first thing, to die for certain diagnosis or certain treatment, surgeries where consent is required. There are two kinds of consent: express consent and implied consent. Express consent means the patient has expressed, means he has either told orally or given in writing. Then it is express consent. Implied consent means it is not told but it is implied. For example, a patient visiting a doctor to a clinic, or he is asking a clinician to visit his house, inevitably or invariably means that he is giving his consent. So that is implied consent. So the consent means it is an agreement or a permission given to the physician. Why it is required? In to carry out certain diagnosis or certain treatment, surgeries. And kinds of consent, there are two kinds: express consent and implied consent. Next, there is something called as informed consent. Informed consent means the patient will be informed about his condition, nature of the condition. or for example he will be told all the risk involved in diagnosis, applying certain procedures, investigations, or treatment. He has been informed about the risk involved in that, and then the consent is taken. That becomes the informed consent. So there are certain exceptions for informed consent, like in case of emergencies, okay, where there is no time to inform the patient and then carry out the treatment. So there are certain exceptions for informed consent. So oral consent should be taken whenever it is necessary. Written consent, however, it is not required in every case. Wherever it is required, it could be taken. And for all medical examination, consent is considered to be very necessary, and it should be free, clear, informed to the patient. If the physician fails to take the consent from the patient, then he is responsible for the act, and uh, he will be responsible for the act, and he can be punished for the same. Then the last point under this is euthanasia. In simple terms, it is mercy killing. Means producing a painless death, offering a painless death to the person who is suffering from a very dreadful disease or incurable painful disease. So there are different types of euthanasia. One is active euthanasia or passive euthanasia. Active euthanasia means giving a positive act to end his life, like it is an act of commission. Example, you give a large dose of drug to hasten death. Certain act is performed to fasten the death. Then it becomes active euthanasia. Passive euthanasia means discontinuing the medical treatment what is given. That becomes the passive euthanasia. Means slowly stop the medical treatment, allowing the person to dehydrate or turning off the respirator. This becomes the passive euthanasia. Again, based on the will of patient or otherwise, it is called voluntary euthanasia and involuntary euthanasia. Voluntary euthanasia means at the will of the patient, euthanasia is performed. Involuntary euthanasia is against, means compulsorily against the will of the person. Means persons who are in certain cases where they are, example, in irreversible coma, where he is not able to express himself. In that cases, then euthanasia is performed. It becomes the non-voluntary euthanasia. So these are certain points which are dealt under medical law and ethics, though not present in the syllabus. Student is expected to know these, particularly euthanasia, secrecy, communication. These are asked both in theory as well as in viva. Next topic is malingering. Malingering, it is a known term which means planfully feigning or pretending a disease, consciously pretending a disease for some sort of gain. Then it is malingering. Example include beggars. They excuse me, beggars. They do certain diseases to attract public empathy, or sometimes soldiers or police officer to escape or to avoid from their duty, they consciously or plan pretending a disease. Then it is called as malingering or feigning of diseases. The diseases that are feigned are many, which will include intestinal colic, dyspepsia, ulcers, ophthalmia, rheumatism, neurasthenia, sciatica, blindness, deafness, vertigo, etc. Example is excessive intake of digitalis, which may mimic a heart disease. Or one more example is eating large amount of carrot, which will produce carotenemia. It is called vitamin A toxicity that may simulate jaundice. So he may plea telling that he is suffering from jaundice to escape from some sort of duty. Then it becomes malingering or feigning of disease. How to diagnose a case of malingering? This requires careful observation, preferably without the knowledge of the person, careful and close observation. If required, certain examinations and investigations could be carried out to confirm the case of malingering or feigned diseases. The next topic is medico legal aspects of acquired immunodeficiency syndrome. So I have not included the introduction of the disease as it is well known for the students. I have included only the ethical and legal points of the disease. So in the papers, they are expected to give an intro about the disease, what type of disease it is, how it is caused, what is the organism causing it, and how it is spread. General details could be given. Based on the marks, they can expand their answers. So here I will be talking only about the ethical and legal issues which are related. So an AIDS patient, ethical issues will include first one, medication and treatment. He has all the right to get his medicine and the treatment. A doctor cannot refuse treating a case of HIV based on the grounds that it is a infection which is scary or dreadful infection. Then disclosure, as I told you, in case of secrecy, he is supposed to maintain a confidentiality. But if the patient is getting into some sort of act in the harm of society or other people involved, then the doctor has the privilege to inform the necessary authorities about the case. Okay, so he is supposed to inform the authorities that a patient has been diagnosed with this particular case, but to general other public he is not supposed to tell the information. Then consent for treatment and blood test. So it is physician's responsibility to take a consent from the suspected case of HIV, even to carry out the blood test, also to cancel for the carrying of the treatment. Employment rights of the HIV should be reserved unless it involves risk to the other people. Now, legal issues related to HIV are Section 269, 271 IPC, which says any person causing spread of dangerous infection unlawfully or negligently, knowing that act can be dangerous to life, can be punished with 6 months of imprisonment. Since HIV falls under a dangerous infection, if a person suffering from the infection is causing the spread of the infection because of his negligence or willfully, then he can be punished up to 6 months of imprisonment. Then coming to section 270 IPC. If any person leads to unlawful spread of any dangerous infection, including AIDS, he can be punished with 2 years of imprisonment. Last one, section 304A IPC. Action against blood bank can be initiated supplying infected blood to a patient, resulting in death of that person due to HIV. Knowing that the blood is infected, if the blood bank negligently allows the further supply, resulting in spread of the infection to other, leading to death, then action can be taken against such blood bank. So the AIDS patient, be it of any social class or category, he has the right to be able to avoid infection. Right to health care means he has all the rights for getting due health services, and it is the right to be treated with dignity without discrimination when sick, and to die with dignity. Then the right to confidentiality, as I already told. So these are the points related to medico-legal aspects of AIDS. So the introduction will include about the disease, mode of spread, causative organism, prevention, then ethical, legal, and rights of the patient. Next topic is rights of unborn child. So unborn means in the mother's womb. As per the Article 21 Constitution of India, no person should be deprived of his life or personal liberty except according to procedure established by the law. So that it constitutes for two aspects. One is right to live. Second one, protection of personal liberty, personal choice or liberty to live. So what the act deals with is, so these are the certain acts which are related to rights of unborn child. The first one is Transfer of Property Act to an unborn child. So this act, section 30, allows a person to transfer his property or her property to the one who is in the mother's womb. So a mother or the father or anyone, he can transfer the property to the person in the mother's womb. It need not be always after birth. So Transfer of Property Act says that section 30, it allows the person to transfer his property to the one is in the womb of the mother. Next is Code of Criminal Procedure to an Unborn Child. So this states section 416 of CRPC. When a woman, suppose a woman be found guilty of some crime, if she is punished with death sentence and if she is proven that she is pregnant, then implementation of the death sentence can be postponed, or it can be converted into a life imprisonment depending upon the case. So that is section 416 of CRPC. A woman who is given death sentence proven to be pregnant, then the implementation of death sentence can either be postponed or converted into lifetime imprisonment depending on the case. Then coming to Hindu Succession Act, section 20 governs the rights of the fetus. So the born child, a baby, as well as in the mother's womb, gets an equal status as the baby which is already born and has the same right on the property. Then coming to rights provided under the Indian Penal Code to unborn child. The section 312 to 316 of the IPC that has given in detail about the extreme priority to be given to the unborn child. So what are the priorities that is given to the unborn child will be dealt under section 312 and 316 of the IPC. So rights of unborn child, what does unborn mean? Then Article 21 Constitution of India, and these are the certain other acts which are related to rights of unborn child. One is transfer of property right, then Code of Criminal Procedure, that is section 416 of CRPC, then Hindu Succession Act in that section 20, and IPC section 312 to 316. Then there is a constitution for NHRC and SHRC, that is National Human Rights Commission and State Human Rights Commission. They will provide a protection of human rights, including the unborn in these two can be dealt. So there are certain functions which are regulated for NHRC and SHRC. Next is MTP Act, or Medical Termination of Pregnancy Act 1971. So the indications for MTP, or medical termination of pregnancy, are basically five. First one is therapeutic. Therapeutic means the continuation of the pregnancy can result in serious health injury to the mother's health. Then it is therapeutic indication. Second one is eugenic. Eugenic means where there is a risk of child that will be born having serious deformities, either physical or mental anomalies. Then it comes under eugenic. Third one is humanitarian. The pregnancy resulted because of rape. Fourth one, social. Pregnancy resulting due to failure of contraceptive methods, as in case of married women. So if she continues, then it can cause further mental harm to the family. Then it can be terminated. Then coming to environmental factor, where the the economic environment where she is living, the mother is living, the continuation of pregnancy can cause injury to the mother's health in future. So keeping that in mind, these are the five indications to cause the medical termination of pregnancy. It can be therapeutic, eugenic, humanitarian, social, and environmental. So the rules of MTP Act include only qualified registered medical practitioner possessing experience can terminate the pregnancy. It should be done in government hospitals or the hospitals which are recognized by the government to do so. If it is a non-government institution, then they will have to obtain license from the chief medical officer. Then consent. Here, in case of MTP, consent of woman is what is required to carry out the act. Okay. The consent of woman will be what is required. Consent of husband is not a necessary to carry out the MTP. And in case to carry out MTP, age proof is not required. A oral statement, a woman stating that she is of her age, that she is over 18 years of age, that is being accepted. In cases of rape, a statement that she is being raped is enough, and she need not produce an evidence of police complaint being lodged or so. Then professional secrecy, it as already told, it is one of the case where confidentiality should be maintained. And if it should be carried out when it is if it is less than 12 weeks, then a single doctor can terminate it. If it is between to 12 to 20 weeks, then two doctors opinion is needed to carry out the MTP. Then coming to the emergency cases, if it is a case of emergency, then consent is not required. Whether it is a government or non-government organization, that consideration also is not required. If it is a case of emergency, it can be terminated by a single doctor, though he does not have necessary training. Okay. And without consulting second doctor, even a non-recognized private hospital also, it can be done if it is a case of emergency. Punishment, if the MTP is carried out not by an RMP, or if it is carried out in unrecognized hospitals. This is exclusion of emergency cases. If it is carried out, then rigorous imprisonment for a term not less than 2 years, which may extend up to 7 years, will be the punishment which is given for MTP. Okay, so these are the points related to MTP Act. Indications, what are the rules and regulations, who should carry out, where it is to be done, consent, age proof, and certain cases like rape cases, what is the punishment involved. Next comes the Transplantation of Human Organs Bill 1994. The major aspects of why this act is being passed, it is to put a stop to the live unrelated transplants, live donations where it is not required. So put a stop for illegal activities. Then if it is a case of required live transplant, then making sure that the donor and recipient are genetically related. And transplantation, the THO Act accepts brain stem death criterion. So in chapter of death, it will be already dealt what is brain stem death. There are certain criteria like Harvard's criterion, etc., which is being carried out to accept the brainstem death. So the Transplantation of Human Organ Bill also accepts the criteria of brainstem death. So according to the bill or the act, what is human organ? It is a part of human body consisting of structured arrangement of tissues which if wholly removed cannot be replicated by the body. So it is a loss which cannot be repaired by the body. Then it is termed as human organ according to this particular act. But bone marrow transplant is outside the purview of this act. Bone marrow transplant is not coming under the purview of this particular act. Then which are the organs which can be donated include kidney, heart, liver, lung, pancreas, eyes, eardrum and ear bones. What duration it should be taken, that will be dealt in death chapter. So the removal of organs from the donor may be done on his authorization or that of a person lawfully in possession of the body. So, if it is a live transplant, then he should authorize for the transplant, or else if it is cadaveric transplant, then legally a person possessing the cadaver, he should authorize for the transplant. If it is a case of unclaimed bodies in the hospitals or prisons, then the transplant may be done after 48 hours based on the purpose. Then human organs can be removed only for therapeutic purposes and for nothing else. Then strict and compulsory registration is required for carrying out a human organ transplantation. Either for removal, storage or transplantation, registration is compulsory. Then the donor must be explained of all the possible risks involved in transplantation. Complications which could arise, hazards related should be explained to the donor. So in case of illegal transplantations, what are the punishments given? So the doctor's name will be removed from the state medical council at least for 2 years and permanently removed from the office. Based on the nature and the severity of the case, the imprisonment up to 5 years and fine of up to 10,000 rupees can be charged on the physician. So there is a set of rules which is called Transplantation of Human Organ Rules, 1995. There are 13 forms which have been framed by the central government. Okay, so this is related to THO Act. What are the features? What are the main aspects of the Act that aims to stop the unrelated transplant and live transplant ensures they are genetically related. And the criteria accepted is brain death, brain stem death. So the student can write the criteria for brain stem death to expand the answers here. Then what is human organ according to the Act? Which are the organs which can be removed, and what is the author, who has to authorize for it. Then only for therapeutic purpose it should be done. Registration is required. Donor must have explained, and what is the punishment which is being given. So all these points should be done under the THO Act. The next one is PCPNDT Act, that is Preconception and Prenatal Diagnostic Technique Act 1994, which is otherwise called the Sex Selection Act. So in the PCPNDT Act, there are about 8 chapters related to it. Okay, so the chapter 1 basically has definitions, basic definitions from what is fetus, what is embryo, who is a gynecologist, what is a genetic laboratory, what is genetic clinic, genetic counseling center. So all these definitions have been given under the PNDT Act in the chapter 1. Now, coming to the chapter 2, there is regulation of genetic counseling centers, genetic laboratories, genetic clinics. In the first chapter, they would have given definitions of genetic counseling center, genetic lab, and genetic clinic, how different it is. So, in the chapter 2, they have given about the regulations, how these centers should work. So basic thing is whether it is a counseling center or a lab or clinic, unless they are registered under the Act, they cannot conduct or help in doing activities related to prenatal diagnostic techniques. So the first thing is registration is compulsory for the centers to carry out the techniques. Then they cannot employ or cause employment or services from a person who will not have prescribed qualifications. So only people with proper qualifications in a registered center can do the diagnostic techniques. Then chapter 3 tells with the regulation of prenatal diagnostic techniques, how it should be carried out, that is being dealt under the chapter 3. Then prenatal diagnostic procedures should not be conducted unless the physician is satisfied that all the there are certain points like all side and after effects of procedures you have explained to the pregnant woman before proceeding with the act. The pregnant woman has been given all the information regarding the technique, that this could be the possible effect of it. Then the age of pregnant woman to be above 35 years. Okay, and she has undergone 2 or more fetal loss. Then prenatal diagnostic procedure becomes a requirement there. So in such cases, you can go ahead. Then pregnant woman who has been supposedly exposed to certain things like radiations, infections, etc. Then prenatal diagnostic techniques can be done. Suppose one more exclusion is pregnant woman or spouse having a family history of mental retardation or physical deformities which are genetic in nature. So to rule out, the techniques can be followed. Then her written consent to undergo that procedure should be in the language which she can understand. That has to be explained and taken. So the communication of sex of the fetus by either words or signs in any other matter to concern pregnant women or the relatives or any other person is prohibited. Okay, so these are prenatal diagnostic procedures exclusions where it can be carried out. How to carry out certain points are very much required. The age of pregnant woman should be above 35. If she or her spouse have a history of genetic disorders, then her consent in written language in her own language to be taken. And regarding the sex of the fetus, no information should be given to her. So those are certain regulations for doing the techniques. Then in chapter 4, central supervisory board. Here, the government will form a central supervisory board. So under this chapter, they have given who are the members, how they are appointed, what is their term, what are the vacancies related, how to carry out the orders. All these have been given in chapter 4. Then chapter 5 deals with appropriate authority and advisory committee. So there are two different authorities. One is appropriate authority, advisory committee. What is the difference between the two? It is explained in the chapter 1. So here in the advisory committee or appropriate authority, who are the members to be present? What are their functions? How they should carry out the regulations under the act? They are explained in chapter 4, chapter 5. Chapter 6, as I already told you, registration of genetic counseling centers, labs, and clinics. So, in this chapter, how to get a registration done for the clinic or lab. What is the procedure of applying for registration? How to obtain the certification? What is the valid period of that certificate? When to renew it? How to cancel them? Or in case if the lab or center is found to be guilty of some crime, what are the suspension, how it is being done. Such things and regulations are done in the chapter 6. Chapter 7 will be regarding the offenses and the penalties. What are the related offenses coming under this act? For example, as I told you, there are certain things where the diagnostic techniques can be used. So, other than this, if the diagnostic techniques are unnecessarily employed, or if the after doing technique, if the pregnant woman is revealed about the sex of the fetus, then all these go for the offense. So, particular offense will have particular punishment, and all those are dealt under the chapter 7. Last one is the miscellaneous chapter, which will deal about how to maintain records in genetic clinics, who has the power to make rules and regulations, which are the powers to make regulations, rules, power to search, seize records from the genetic clinic. So, all these are dealt under the miscellaneous chapter 8. So, in the exam, first thing is PNDT Act. Here, chapters are 8 in number. In brief, about what they deal with, and the two important points to be highlighted is the centers should have the registration to carry out the act. Second one, the whoever is employed in that particular lab or the clinic, they should have all required qualifications. Then, what are the criterias where these techniques can be put, or where these techniques can be employed? What are the exclusions? So, those points should be highlighted along with this brief description of the chapters. Next one is the Clinical Establishment Act. So, regulation of the registration and regulation of clinical establishments in the country. So, what is the meaning of this clinical establishment? In simple words, any hospital, nursing home, clinics, maternity home, or any institute which will offer services or facilities, either diagnosis, treatment, care of the patient, ill, injury, deformities, and in any recognized system of medicine. Any recognized system of medicine which is established, administered, either it is maintained by a single person or a group of people, that becomes the definition of clinical establishment. Okay, any center which offers procedures either for diagnosis or treatment of the patient, then it is called as clinical establishment. So this clinical establishment act will give regulations regarding how to carry out registration of a clinical establishment in a country, and what are the requirements and regulations under that. So in Clinical Establishment Act also there are 7 chapters. First one is the preliminary chapter, which gives basic definitions and idea about the act. Chapter 2 is National Council for Clinical Establishment. So how to put up a national council? Who are the members present there? What on what basis they are going to appoint the members? How they will carry out their functions? So that is chapter 2. Chapter 3 is registration and standards for clinical establishment. State council clinical establishments, in how the information should be given to national council, what are the who are the authority for registration, how to carry out the registrations, what are the conditions required, all these are done under chapter 3. Chapter 4 is what is the provision to obtain the certificate. It could be a provisional certificate or a permanent registration certificate. How to apply it, who will verify it, what are the points for verification, what is the validity, that is dealt under chapter 4. Chapter 5 is registers of clinical establishment. So there should be a national council register and a state council register which will maintain the database of all the clinical establishments. Chapter 6 will be regarding the penalties which is given on the doctors. If anything offense related to the Clinical Establishment Act is being done, for example, not doing running a clinic without registration, so such things are meant offense and they are liable for punishment. That is dealt under chapter 6. Then chapter 7 is miscellaneous general information regarding it. So these are the points related to Clinical Establishment Act. So you will have to tell the year, then what is the meaning of clinical establishment, how many chapters are there, and brief about that. Next is duties, international code of medical ethics. So the international code of medical ethics, it is derived from the declaration of Geneva, adopted by the World Medical Association in 1949. So it was amended in 68 and 83. So basically there are three aspects in this. One is duty of physician in general, duty of physician to sick, and duty of physician to each other. So, duties of physician in general. Example, physician should always have a highest standard of professional conduct, and he should be dedicated in providing competent medical services to his patient, and he should deal honesty with all his patients or colleagues. And if there is any incompetency, he should strive to correct it and expose it if it is under his discretionary. So these are the ethical conducts. And so there are certain practices which are unethical. For example, self-advertisement by the physicians. Unless if it is permitted by the law of the country, too much of advertisement about oneself is considered to be unethical. Not giving respect to his patient, that also is considered as unethical. Then physician should involve and be cautious in discovering new techniques, and he should always be updated whatever new techniques and treatment are there, and he should maintain thorough professionalism. So these are duties of physician in general. Then duties of physician to sick. So these are in general, like a physician should always remember that he is there to serve the humanity, to preserve the human life. He should maintain confidentiality on whatever he knows regarding his patient, being loyal to his patient, and whenever there is an emergency based on humanitarian grounds, he will immediately plunge into the service and provides care and render services to the needy. Last one is duty of physician to each other, means towards the colleagues, having a proper conduct and behavior towards his fellow colleagues, not entice the patients from his colleagues, and observe the principles of Declaration of Geneva. All these comes under duty of physician to each other. So this is regarding International Code of Medical Ethics. So coming to the last topic, Consumer Protection Act or CPA 1986. So basically it will seek to provide for better protection of interest of the consumers. For that purpose, provide for establishment of consumer councils or authorities for settling consumers dispute or matters connected with it. Nothing but in simple words, this act protects the interest of the consumers. and to solve his problems there is establishment of certain councils, and there are certain authorities who quickly carry out the cases and solve them. Whatever matters are concerned, that is dealt. So this will cover all private, corporate, public sector enterprises, everything. So there are basically three forum: district, state, national commission. They are established. Then it tells about what is the difference between defect and deficiency. Both are faults or imperfections. So defect means fault or imperfection in the quality, quantity, purity, so on. Deficiency means insufficiency or inadequacy in the quality or manner of performance. So it describes the difference between the defect and deficiency. And then in the Consumer Protection Act there are description regarding the redressal agencies. So as I already told, there are three redressal agencies. One is district forum, then state forum, and national forum. District forum will be having usually three members, two from the state government and one they preserve two from the state government which are nominated. They will be usually serving or retired district judge. So the claims up to 20 lakhs will be dealt under the district forum. State forum or state commission, they will have members usually from retired high court. Claims between 20 lakhs to 1 crore is dealt under the state forum. National commission will consist 5 members, preferably the in service or retired Supreme Court judge. So this is over a crore rupees. If the claim is involved, then it is dealt under the National Commission. So redressal agencies are three: district, state, and national. So up to 20 lakhs district, 20 lakhs to 1 crore state, above 1 crore is the National Commission. Then next it describes about the manner to file the complaint. Like who can file the complaint? It can be a consumer association, state government or central government. They can file the case. And procedure should be every plaintiff, whenever he has given the complaint, the opposite party will be informed about this complaint within 3 weeks from when it is being lodged, and the opposite party will be given 30 days time to address the issue. It need not be fought by the lawyers. The dispute will be settled based on the evidence which is produced in the court of law. Then appeal. The aggrieved person or the plaintiff, he can prefer to appeal either to state commission. If he is not satisfied, he may move on to the national commission with the complaint. Then relief. Based on the evidence which is being produced in the court of law, if the plaintiff has been proven, the complaint has been proven correct, then the opposite party will be charged for the complaint and he has to repay. Suppose if it is any goods, defective equipment is given, then the court will order them to replace the equipment, or amount whatever is there that should be given. Suppose if the plaintiff has proven guilty, that he is false accusation, then he will be complaint will be dismissed and he will be allowed to pay amount usually not exceeding 10,000 rupees. And relief means to make sure that the plaintiff or the complainants, they get relief immediately. Opposite party properties can be attached to it and disposed to count the compensation. Then limitation period, any case of coming under the act, it should be within 2 years from the date where the incident or action has occurred. Then CPA and medical services. So the thing is, medical practitioner, hospitals of medical negligence being complained. So that also comes under CPA, and they are can be sued for compensation under the act. Then last one is the compensation. If it is a case of doctors, they are liable to pay the compensation to the patient. Suppose if the professional negligence has been proved, then whatever compensation is there, that he is supposed to prove it in the court. So these are the points under the Consumer Protection Act. when the act was passed, when was it amended? Then basically three basic forums are there at district, state and national level. Wow, who can apply the cases, what is the procedure, what are the penalties, what is the period appeal, and the medical services also come under CPA. What is the compensation means here. So with this I have concluded the session.
Thank you so much, ma'am, for this insightful session. It was a very informative session, ma'am. It will be very helpful for all the exam ongoing students who will be able to see the video and understand the topics clearly. And it will be very helpful for them in last moment revision as well. Thank you so much for accepting our invitation. Even in your busy schedule, you took some time for this session, where you have explained the topic very detailedly. Thank you so much, ma'am. Any queries regarding this series will be forwarded to you, ma'am. Your answers will as well be forwarded for them as well. Thank you so much, ma'am. And this video will also be posted in our YouTube channel where the maximum student can view this, ma'am. Thank you so much, ma'am.
Okay, thank you.
Thank you, ma'am.